In re Estate of William Rucker.
Good morning, Your Honors. I'm Jonathan Williams of the Nashville Bar. I represent the appellant, Miss Betty Rucker. I don't need to reserve any time, so I'll get right to it. The issue in this case is whether the trial court erred in admitting a copy of the lost will of Mr. Rucker to probate. But before I begin, I need to address one thing. There is an error in my brief, and it's incumbent on me to bring it to your attention. When I was preparing for this argument Monday, I noticed that I cited In re Brown, which is an unreported decision. I cited it 3 times as holding that the proponent of a lost will faces what I put in quotes as an almost impossible barrier. In re Brown does not say that. I misread the words and loved it and went with it, and I apologize. That is not the law. The correct statement of the burden a proponent of a lost will faces is in re Shrum, which is a reported decision. It says the person seeking to set up a lost will faces and I'll use quotes, severe handicap. So almost the same, but I just wanted to make sure I address that. So I'm going to cover 3 things briefly. First, the trial court erred in admitting the copy of the lost will to probate because the actual will, the copy of the will, was never introduced into evidence during our trial. It was not made an exhibit. It's just simply attached to the petition to admit the will to probate. There's no testimony about where it came from. Ms. Vu, the proponent, never testified about how she got it or how it came to her possession. And in the trial court's judgment, it's mentioned that, well, no one made an issue of this. Well, Ms. Rucker, as the defendant, has no burden of proof. I didn't say anything until closing. I made a big issue of it. The very first thing I said in closing argument was, you have to dismiss this petition because the will is not an exhibit. We don't know how it came into her hands. The law, talks about we have to trace the will to the hands of the testator. No one said this is his signature. No attorney testified that I prepared it in 2017. The will's a 2017. The copy is dated that. No one testified where they found this copy. So just on an evidentiary issue, if we're going to admit a will to probate through a contested hearing, I think it has to be admitted into evidence and supported by some facts. Number 2, this court should reverse the trial court's judgment and dismiss the petition to probate the copy of the will because the trial court applied an incorrect legal standard. And if you look at page 112 of the record, that's a page of the judgment, 112. There's a line in it where the trial court said, at no point during all of this is the intent to revoke present by the decedent. That means the trial court put the burden on Ms. Rucker, who's the opponent.
Didn't the trial judge in the order more specifically indicate that the burden was on the other party? And doesn't the order lay out the burdens in this case? I mean, that seems like a pretty aggressive reading of that statement by the trial court judge in the context of an order that properly identifies the burden.
Well, I respectfully disagree that the trial court's judgment, that the judgment order doesn't even say the words clear and convincing. And we know from Shrum v. Powell, to overcome the burden of revocation, the proponent of the will has to have clear and convincing evidence that it was not revoked. So I'm arguing that the trial court said that there was no intent to revoke. The presumption does that. The presumption assumes revocation. So
is that really a burden issue in terms of who has the burden, or is it a matter of the extent of the burden?
The way I read the trial court's order was that who had the burden. Because it's never, in the trial court's order, it never says, Ms. Vu has the burden by clear and convincing evidence to overcome the presumption of revocation, and here's how she did it. Instead, it says, here's what the facts were. There's no intent to revoke, therefore I'm admitting the will to probate.
Is the question of whether the evidence rises to the level of clear and convincing a fact question, or is it a law question when this court is reviewing?
When this court's reviewing it, it's a de novo review. So it's you look at it the way you want and you apply the law correctly. You're not bound by the trial court's decisions on law. So my argument is you can do, in a de novo review in this court, you can look at the facts, reverse the decision, and dismiss the petition. Clear and convincing evidence in our state is defined as evidence that is so clearly shown that there is no serious or substantial doubt as to the correctness of the conclusion drawn from the evidence. So let's look at the evidence. This is my third point. If we apply the correct legal standard in this de novo review to this evidence, it requires reversal and dismissal. Mr. Rucker is Mr. John Rucker is the decedent's brother. And Mr. Rucker, the decedent, died from COVID in 2020. Before he died, the decedent went to Detroit and met with his brother. And there was a discussion. He said, I was going to do a will. It's something I'm going to do. Right before he died, there was a phone call. And the decedent told his brother, everything is taken care of. The decedent told his brother this Taylor Road property, which is just the house that he lived in, that he wanted that property to go to Miss Vu and everything else to be split between his daughters. But the 2017 will doesn't match those intentions. The 2017 will disinherits the entire family and leaves everything to Miss Vu, even properties that had been titled jointly. There's some weird allegations that were never proven, and there was no trial testimony about it, about my wife made me sign a deed and this and that. So the two facts are at odds. In 2020, I'm going to go do a will, and this is what I'm going to leave this one property to this person. But the 2017 will, which they try to get to probate. So again, have we overcome the presumption with that alone? But let's look at Ms. Johnson's testimony. Ms. Johnson was a friend who worked at the VA. And she, in 2020, 3 years after the 2017 will was created, she took Mr. Rucker, the decedent, to a law firm in Nashville to get a copy of his will and make some changes. He came out with some papers. The will, which is in the record, was prepared by Cheryl Gwynn with an office on 2nd Avenue. I went through great pains with Ms. Johnson. Were there big buildings? No. Did you go downtown? No. Were you on 1st Avenue, 2nd Avenue, 3rd Avenue? No. So the inference there is they didn't go to this office. The inference is this will's been revoked. That's why we can't find the original. Again, Ms. Rucker doesn't have to prove any of this. Ms. Vu has to overcome it with clear and convincing evidence that it hasn't been revoked. I'm just doing one more for my client.
Counsel, the trial judge's understanding, and maybe I'm misreading the order, but it seemed to be that the issue was revocation rather than formation. That there was at one point a 2017 will, and the question then became whether that was revoked or not. Correct? I mean that's really the question the trial judge was trying to answer in this case. Am I wrong about that?
No, you're right. I'm holding the document.
Right.
There's a document that says this is the will of Mr. Rucker, and it's dated 2017.
So your argument essentially is that the intent, all the testimony, and the testimony seems pretty consistent at this point from what you referenced in your brief, that the testimony is that he wanted to evenly split. He had a particular property in mind for one particular daughter, but all of the other property wanted to be split, and that suggests that the 2017 will wasn't the will that he still was operating under or intended to be operating under. Is that more or less a correct understanding?
Right. That's Ms. Rucker rebutting any positive proof to overcome the presumption. That's the defendant saying you can't overcome the presumption of revocation because it even supports the defense.
And the trial judge's finding in this case is that was his intent, was to have the estate divided evenly among among the children.
But the will, yes.
But the 2017 will is all to one daughter. I
It
understand.
does not do that.
The trial judge works through sort of the practical impact, let's say, describe it as, of the 2017 will, and sort of seems to arrive at a rough sense it's roughly consistent with that intent. Am I correct in understanding, though, that there's one daughter that ends up with nothing, essentially, under the even sort of under the practical operation here in terms of what's under whose name? Because I guess the wife has something under her name, one of the daughters has something under her name. There is one daughter who ends up here with essentially nothing, right?
I read that part, and I understand where you're going. Those are the non-probatable assets, the assets that pass outside of probate based on jointly held property. My position is that that's not the issue for this court. But if we're looking
that
to
understanding, though, there's still a daughter who ends up with nothing here, right? Even if we do consider
Right.
things outside the probate estate, there's still one daughter who sort of ends up with nothing at the end
It's
of the day.
not clear to me whether, because I think you're talking about the one who says, no, I rent that house out now, or something like that.
There's three daughters, right? And we have
There's two,
there's
and one
two.
that alleges to be.
Right. And so with the two daughters of the marriage, that one of them there's nothing identified by the trial court judge that person is receiving outside the probate estate.
I think you're correct.
Okay.
I think.
Okay.
I want to just compare this case to the case law in Tennessee. So back to In Re Estate of Shrum. Mr. Shrum met an employee at a bar. He wanted to create a will, and he got a will, and he left this employee everything. He gave her a copy. He puts his original will in the shack behind his house. 1 year later, the shack burns down. The shack then burns down, and 1 year later he dies. So we know where the original is. 1 year later, the house burns down. The trial court held in that case the proponent of the will could not overcome the burden of revocation. Then In Re Estate of Leith, which also cited in my brief, it's a reported decision. Mr. Leith gets a will done in 1996. 36 days before he dies, he goes to his lawyer's office and says, with his will, and says, I do not want to make any changes, and this is my will. This is the way I want it done. He's killed 36 days later. There's a issue about whether his mother or his wife killed him. That's how he got into litigation. But even though 36 days before he died, he said, this is my will and no changes, the trial court said you cannot overcome the presumption of revocation. And then back to In Re Estate of Brown, which is a non-reported case attached to my brief. The day before Mr. Brown died, he called some people into his room, and he pulled out a box of papers, life insurance. And out of the box, he said, this is my will, and he unfolds it, and it's the original will, and he dies the next day. And the court said that proponent overcame the presumption. So if we're just looking at timelines, 1 year, not enough, 36, this will was done 3 years before Mr. Rucker died, with all of these statements in the meantime. Says, I want to treat everybody equally, I want to make some changes, I'm going to go do that, I'm going to go meet with the lawyer. He's taken to a lawyer's office. So, and again, these are facts that support the defense or Ms. Rucker's position. Ms. Rucker's position. So with all of these facts, trip to the lawyer, telling people you're going to make changes. The will's not even found where it should be. It was supposed to, my will is in this lockbox. We had to go drill a lockbox. There's nothing in there. The will is never introduced into evidence. There's no evidence about how it's created. The presumption of revocation in this case was not overcome by clear and convincing evidence. The trial court's decision must be overturned on a de novo review and the petition dismissed. Thank you very much.
No questions. Thank you. I believe that concludes the docket for the morning. Would you please dismiss court?